starting next Monday.
Judge, will you still allow participation by attorneys and parties via Zoom, or do you want everybody to be there in person?
To the maximum extent possible.
Great.
That's the directive from the Supreme Court, and I intend to follow their directive.
Good.
Okay, we're streaming. Shannon, you can put us on the record now. This is a matter of Drake versus 1212 Woodsum Street. Mr. Fallahy for the plaintiff, Ms. Dennis for the defendant, and it looks like a defendant representative is present. His name is on the screen. Go ahead, Mr. Fallahy.
Thank you, Judge. We have competing motions to compel today, Judge. How would you like me to proceed? You want me to just argue my motion and then wait on my response to the other side, or how would you like me to do that?
That's fine. I frankly was only aware of one, but that's fine. I can hear them all. Go ahead.
Okay, thanks, Judge. So I'll discuss first my motion to compel that I filed. As you indicated, Judge, this is the case of Drake versus a purchase trust, specifically 1212 Woodsum Street Purchase Trust. My client's the plaintiff. We filed a complaint to quiet title. A counterclaim for specific performance and breach of contract was filed by the defendant. One of the questions in my discovery requests, specifically a request to produce documents, was that I get a copy of the trust. And I've gotten a significant amount of pushback on that from both Ms. Dennis and her client. As indicated in my motion, I offered to draft a protective order that would require me to not disclose any of the information in the trust other than for use during this litigation. I attached Mr. Nick, the trustee, I attached his deposition testimony as it relates to some of the questions I asked him on the existence of this trust. I am very strongly questioning whether this trust even exists, or if it was potentially drafted and entered into after the real estate documents in this case. The defendant is the trust, and so if there is no trust, there would be no ability for this non-existent trust to even enter into a contract, and could be the basis for me to file a motion for summary disposition. And so I have, again, discussed numerous times with Ms. Dennis. I've sent emails, asked for disclosure of the trust agreement. They have completely refused. I've offered a protective order. I was left with no alternative, Judge, but to file this motion. There was no other alternative. And now Ms. Dennis in her response indicates that they're willing to show it to the court, but that I don't get to see it. I don't think that's allowed under our court rules. I've never heard of that type of situation happening before in any of the litigation that I've handled in the past. And I think, quite frankly, that I'm entitled to see it. I think that that's a big piece to this puzzle. And so for all of the reasons stated in my motion, I would ask the court to grant our motion to compel. I would ask the court to order. My understanding is Ms. Dennis has a copy of the signed trust, so I could probably have it emailed to me very soon. So in my motion, I requested that the court order that the trust be turned over to me within 24 hours of this hearing, but preferably sooner if possible. I'm still willing to enter into a protective order that indicates that I will not disclose any of the information in the trust and that it solely be used for litigating the pending matter before us. My client is willing to be bound also by that type of a protective order. And Judge, I would ask for $770 in costs and attorney fees for having to bring the motion. I had to draft the motion. We had to obtain essentially the deposition testimony, and I carved that out from the transcript from the deposition. Now we're appearing in court. We're going to have to draft an order. My hourly rate in this case is $250. It's going to take basically 3 hours plus the $20 filing fee. I don't think that the request for attorney fees is unreasonable anyway, and I think it's allowed by MCR 2.313A5. So we would ask the court to order that. Thank you very much.
Thank you. Ms. Dennis?
Your Honor, I represent the trust here, and of course, in this capacity, Mr. Nick, who is present but not visible because he's in his ambulance in this matter. And what our position is that the trustee believes that he has the responsibility to the trust to keep the terms of the trust private. We agree that the existence of the trust is relevant, but the body of the trust, and I understand it's about 8 pages long, is not relevant to this proceeding. Yes, it is relevant that the trust exists. It's irrelevant that the trust existed prior to the option agreement and the sales contract being entered into, because it is a party to that contract. But the body of the trust, which contains proprietary information that Mr. Nick, as the grantor and trustee, hired an attorney, not me, Your Honor, but hired an attorney to produce, and that is a trade secret in a sense for his real estate business, is not relevant at all to the issues here. The issues here concern the option agreement, the sales contract. Did the trust properly exercise its responsibilities under those documents? Did it exercise its option correctly? Was the defendant, well, not the defendant, but the plaintiff here wrong in not proceeding with the sale that the trust was concerning? All those issues have nothing to do with the body of the trust. So we say that this isn't relevant. The reason we offered to the court to view the document is to reassure Mr. Fallahy and his client that the trust exists. And we would just ask the court to look at the document. It is in the original of it is in a bound volume. I do have a scanned copy that was sent to my client, but I don't actually physically have the bound volume. But Mr. Nick could bring it to the court could view it, and then inform the parties that we believe that the trust appears to exist. So, but the body of the trust is not relevant, and therefore we think it is not properly discoverable under the rules.
Relevance is not a condition for being subject to discovery. I'm ordering that the full trust be produced, a full copy of the trust. I will reserve the question of costs and attorney fees until after Mr. Fallahy has a chance to review the trust. If frankly there's nothing proprietary within the body of the trust, I might very well consider awarding some kind of sanctions. Mr. Fallahy, you'll prepare that order.
I will, Your Honor.
Timing wise, I can only act by a written order. So within 24 hours after entry of the order, I want an electronic copy sent to Mr. Fallahy. And what's the other motion?
Your Honor, you may not recall, but you did permit us to file our response, our motion to compel the tax returns of the plaintiff. This was part of our discovery request, and similarly, they refused to produce their tax returns. And I did file a motion, which I think you should have, Your Honor. It's not only it should be in the file, but also it was sent to, I think, to Mr. Fleming so that you would be sure to get it. It actually didn't get filed until Monday, but Mr. Fallahy hasn't filed a response to it. And we've asked for the tax returns, and I set forth in our motion reasons why we wanted it. They claim that the tax returns are irrelevant, but we believe the tax returns are relevant. And so the reasons that we set forth in the motion is that, I'm just trying to, there's a response, excuse me. Those are set forth on, I think, the 4th page of the motion. One of the reasons is that we've taken the deposition of Ms. Drake. She has denied that she ever rented out the subject property here. We believe that may not be true. We think the tax returns may show whether or not she ever rented it out and therefore took rental income as part of her reported income and or use the depreciation deduction. So that would be relevant for impeachment because she testified under oath that she had never rented it. It also might reveal why halfway through the option period, she apparently decided that she didn't ever want to sell this property to the trust anymore, even though, I mean, she basically, by the end of 2 or 3 months after she entered into the option agreement, she instructed her attorney to tell the trust that she was terminating the agreement, even though the option period had not yet run. We find that inexplicable. Perhaps the tax returns will lead to some information in that score. Also, there's an issue.
Hold on. What difference does it make what her reason was? Either she was legally within her rights to terminate the option or she wasn't. The reasons don't matter, do they?
Well, they matter tangentially, I guess I would say. Of course, our position is that she had no right to not follow through with the agreement. But there's also this issue about whether she was renting the property and furthermore, when, if at all, she lived in the property. And that's relevant because the city eventually took away her personal residency exemption and charged her extra fees. And the trust here paid those fees as part of the option fee that was provided for in the option agreement and the sales contract. And she still maintains that the city was wrong, but she didn't appeal the decision. But so the tax returns may indicate that also. When, if ever, did she live in this property? So we just think the tax returns are relevant here, and we don't see any particular reason why we shouldn't get them.
Mr. Fallahy?
Thank you, Judge. I think this motion to compel has followed along in a bit of a tit for tat type scenario in this case. My client's tax returns have zero relevance. I mean, this is just ridiculous. This is a fishing expedition, by filing this motion by the defendant. Judge, the counterclaim by the defendant is for 2 things: specific performance and breach of contract. I don't know how my client's tax returns, according to the elements of those claims, have anything to do with that. I mean, it's not relevant in any way. I look at these 4 reasons listed in the motion, and Ms. Dennis didn't even discuss here today the last one. The last reason she indicates, and I quote, "The tax returns may indicate whether the plaintiff / counter defendant has the financial means to pay any judgment that may be awarded." That's not a reason to turn over tax returns. Your question to her was an exact question I would have, Judge. The fact that my client's tax returns may show whether she was living at the property, that has nothing to do with specific performance claim or a breach of contract. Zero. So I think this was just done because we filed the motion to compel on our side. I would indicate to the court that the discovery requests that I received from Ms. Dennis appeared to be almost a mirror image of the ones that I had sent to her. So it's almost like she just amended them and requested the same information from us that we requested from the other side. The reason I asked, and I guess we need to get into this a little bit, I did ask for the any tax returns filed by the trust, because again, it goes to the existence of the trust. And that was my main reason for doing that. There's no reason at all that my client's tax returns should be turned over to the trust. And so we'd ask the court to deny the motion and consider attorney fees being awarded to my client for having to defend this motion, which I find to be very frivolous, Your Honor. Thank you very
Your
much.
Honor.
So, hold on a minute. So what's your client's complaint in this case, Mr. Falley? Help me understand the underlying dispute. Obviously, it involves an option and whether or not it should be enforced. Does it go beyond that?
No, that's it, Judge. We filed a quiet title action. I'll give you the 2-second rundown. The parties entered into an option agreement. It's our position that the closing did not occur by the required date. Time was of the essence of the agreement. The defendant was required to schedule the closing date. It says that in the documents. The payment was never tendered. This is a very similar case to one that this court has had with one of my partners recently. It's not a difficult factual scenario, in my opinion. And quite frankly, I plan to file a motion for summary here in the near future. So yeah, it's a quiet title claim on our side, Judge, and on the other side, it's 2 claims: specific performance and breach of contract. That's it.
All right. I don't believe the tax returns are likely to lead to discoverable information, so I'm going to deny the motion. I will simply reserve the issue of attorney fees for a future date. Mr. Fallahy, you'll prepare both of those orders?
Yes, Judge. Is it okay, Judge, if I just prepare one order that reflects your ruling on both motions? Okay.
Certainly.
I'll go ahead.
I mean, I just
I'll do
wanted
that.
to briefly, can I briefly respond? I recognize the court has ruled, but we do reject the notion that this was a tit for tat order. We made a request for tax returns. They made a request for the trust tax returns. We responded to that request. They didn't. They would not respond to our request. All these discovery requests preceded the motions before the court. So we had a sincere desire to get the tax returns, and the court has apparently ruled. I mean, from our perspective, the tax returns are far more relevant than the body of the trust agreement. But we will, of course, stand by the court's order.
Thank you. Have a good day.
Thank you, Judge.
Thank you, Your Honor.
John, did you get that? The email? I didn't even know there was a second motion up today. The only thing I had was Nick's, and I didn't have a response to that. Let me. Good morning, Susan.
Good morning.
Rebecca was here earlier on LaFlamme's, told me you're really close. I gave a new date in 2 weeks because I'm not here next week, and she said it'd probably be in early next week. I'm good with that.
Yeah, we've got an agreed upon judgment. It's just a question of getting the signatures around, is my understanding. Thank you.
Yep, that's what she said. Have a good day.
Bye.
Bye. This is the matter of tolls versus Buckler.
Good morning, Your Honor. Christina Fisk on behalf of the plaintiffs, Stephen and Teresa Tolles.
Eric White on behalf of the defendants, Buchler only, not as to Mahoney.
Okay, and this is a motion for entry of a default judgment. It does not appear to me to be for a sum certain. So I think it is necessary for me to have some kind of proofs to support the judgment. I note that there are affidavits that have been submitted in support of the default judgment. You're only seeking a default judgment as to the Maloney defendants?
Your Honor, originally my motion was filed against all of the defendants prior to Mr. White filing his appearance last week. I understand Mr. White is here today to ask the court for the opportunity to file a motion to set aside the default. I recognize the court's very likely to grant that opportunity. I would like to see that motion. Mr. White and I had some exchange relative to a voluntary setting aside of the default. In most circumstances, I would typically grant that request, but under the facts and circumstances of this case, Judge, I don't believe that there is just cause or meritorious defense in light of the simple and straightforward facts of this case. So I would recognize that the court is likely to grant Mr. White the opportunity to file that motion so that we can hash that out at a later date. But to answer your question, yes, I have nothing in the way of communication of any kind from Mr. Maloney. So today I would say I'm here to ask the court to enter judgment with respect to Maloney. If the court prefers to reserve that, if the court prefers to reserve entry of an overall judgment pending some argument by the Buchlers, I understand that if the court wanted to reserve the opportunity to put on proofs of the damages at a later date. I feel like this is kind of one of those situations, Judge, where entering a judgment against Maloney's might be difficult before we hash out the details of the issues with the Buchlers, but the fact remains that Mr. Maloney hasn't defended himself, and the claims are the same as laid out in the brief. The damages are the same. So seeking some guidance from the court in this respect, of course, is appreciated as well.
So the Buchlers engaged the Maloney defendants to harvest some trees from their property, and the Maloney defendants took more trees than they were supposed to?
No, Your Honor. No, that's not the claim, Judge. The claim is that the trees are located on my client's, the plaintiff's property, that the Buchlers engaged Maloney to cut those trees. Maloney didn't do, with respect to the claim against Maloney, Maloney had an obligation as a tree service to do some due diligence in determining whether those trees were actually located on the property of that person that engaged them. Didn't do that, went ahead and cut down 14 mature 88-foot trees. And so here we are.
Right. So your claim is that Maloney cut down trees on your client's property as directed by the Buchlers?
That's correct, Your Honor. That is correct.
I mean, I frequently hear of tree harvesters that go in and cut more than they're supposed to. It's a pretty common occurrence within the industry.
Right.
But that was the piece. Where did the Buchlers fall into this? And I get if they're the ones that directed Maloney to do that, they might have some exposure. And that's probably going to be the dispute here, is whether or not they told Maloney to take trees off their neighbor's property. Mr. White?
That's not really the dispute, Your Honor. I have an affidavit of meritorious defense. It's been signed. What I'm asking the court to do is, I'm going on my first vacation in 3 years next week. And if you would be kind enough to maybe set this until the 9th, you would not incur the wrath of my wife. I can file the motion timely Monday, Tuesday. We could have that hearing a week from.
In all fairness, Eric, I don't have a problem with that either. The problem is I'm then going to be on vacation the week after the 4th of July. So if we could
Whatever works for
reschedule that.
everybody. I don't think that there's a big timing issue as far as anybody being prejudiced. So whatever works for everybody. I was just trying to make it quicker than normal. Whatever the court would do. I did reach out to Mr. Maloney. He's not called me back. My clients indicate that this is like a legitimate tree business that he has. I'm rather surprised he didn't respond and doesn't have some type of maybe insurance coverage, but I'll continue to explore that. But I'm just asking the court to put this over so I can file my motion and we can address it all at one time. And I appreciate that. Whatever the date that works for Ms. Fisk.
I think that makes good sense this morning. So I'll give you that opportunity. And obviously Ms. Fisk can challenge at the motion to set aside the default, and we'll hold the default judgment hearing off to a future date. If you two can work out the timing of when you're both going to be available, whatever works for both of you is fine with me.
Okay, that works for me.
Christina, whatever you
that.
need for a date, just let me know.
I will do that, Eric. I'll send you an email.
Thanks so much. See y'all
Thank you,
later.
Judge.
Thank you, everyone. Have a good day, good weekend.
You too.
And a good vacation. Well, he's gone. I can't. Well, you can have a nice vacation, Christina.
Thanks, Judge. Hopefully you do too.
I'm on vacation next week, so.
Excellent.
Yeah,
Enjoy.
I picked a week where it looks like